This is a timely topic and one that should be on the forefront of everyone's mind. My name is Rob Owings. I'm one of the attorneys with Frost & Associates in the estate planning division. Joining me are my colleagues in there, and type your questions to us. They'll come through. We may answer them right away if they're timely with the slide, or we may defer them to the end based on whether or not that's something we're going to touch on later in the presentation. So I will turn this over to Randy now, let him start, and we will proceed from there. And again, thank you everyone for joining.
Well, let me reiterate what Rob said. Thank you for joining us. The thing about life is that when you lose a loved one, a couple of things happen. There's pain from the loss, and there's potentially chaos as you try to sort it out. Unfortunately, I've had a couple of losses in my family in the last 18 months, so I understand that very, very closely. What we're going to talk about is the basics of organizing your estate planning, because statement that we like to use, if you are ill and you come to see us, we can fix a lot of things in a hurry. What we can't fix is when something happens fast. So this is going to give you an overview of what estate planning is. You may already have one. You may need to take another look at it to make sure it does what you want, or you may not have one at all. So this will at least be a reminder course in everything that you need to know about estate planning. As the title suggests, Estate Planning 101. Leanne, if you want to roll the slide.
Great. Okay, so the first thing that we're going to talk about that's really part of estate planning, but isn't always captured in what people think of when they think of estate planning, is really incapacity planning. So incapacity planning is the planning for hopefully an event that will never happen to you, but you never know. And it's planning for the event that you might at some point be unable to manage your affairs or to make decisions about yourself, whether that's financial decisions or healthcare decisions. Incapacity planning really covers both of those things. And the primary purpose of incapacity planning is avoiding having to go through a guardianship. So if something happens to you and you're not able to make your own financial decisions, or you're not able to make your own decisions about your medical treatment, the default, if you haven't done incapacity planning, is that you would have to, you or the person who's trying to make these decisions for you would have to go through guardianship proceedings, which are court overseen proceedings, rather time consuming, rather expensive, to legally nominate a person to be your guardian and manage your property and your affairs. So by planning in advance, you can generally avoid having to go down that path. And not only can you avoid having to go down that path, but you can make sure that the person that you would want to be in charge of these things for you is actually in charge of these things for you. So the primary documents that we would use in incapacity planning are a durable financial power of attorney for financial affairs, a healthcare power of attorney, and a living will document. Let me scroll, I think. Okay, so the financial powers of attorney are going to nominate a trusted person to make financial decisions for you if you're incapacitated or otherwise unable to. And then the other thing that it does is it would select somebody to serve as guardian for you in the event that, unfortunately, one is needed. So they're very customizable documents. They can really cover a lot of different circumstances. And, they can cover anything from nominating a person to handle your tax returns for you, to taking distributions from retirement accounts, generally managing your paying bills or paying your mortgage, investments, etc. selling real estate, all these types of things would be covered in a financial power of attorney. And then on the other side of things, healthcare directives would avoid the need for an appointment of a guardian of your person. So the two healthcare directive documents are a living will declaration, and that's a legally binding statement of when you do not want artificial life-sustaining treatment. So typically they would say something like, if you are in a persistent vegetative state and you're not expected to recover, or your death from a terminal illness is imminent, then you don't want to have artificial nutrition or hydration. It's different from a DNR, which is when you don't want to be resuscitated. The living will is just a statement about when you don't want artificial life-sustaining treatment. They can also be used for nominating the person that you would want to be in charge of disposing of your remains in Maryland. And then the other document that's important on the healthcare side of things is really a counterpart to the financial power of attorney, where the financial power of attorney selects somebody and gives them authority to make financial decisions for you. The healthcare power of attorney does the same thing for healthcare decisions. And in Maryland, you can have two different people doing the two different roles. They're quite separated. So that would be the person who would decide what kind of treatments you want to have, where you want to be treated, if you want to be kept in your home rather than sent to a nursing facility, whether you can be admitted for, whether that person can submit you for voluntary admission for mental health issues. And it also would serve to nominate a guardian of your person in the event that one is needed. So just wanted to get through that before we jump into estate planning. It's sometimes overlooked, but I would say that this incapacity planning is just as important when you're planning for your estate. So with that, I will turn over to Rob to talk more about, oh, actually, it looks like we have a question. Let's see. Does a living will have to be prepared by attorney and be witnessed and be notarized? So the answer to that is no. They do not need to be prepared by an attorney. And the manner of execution actually depends on how the document is done and if it is a document. So Maryland law actually permits a living will, well, it's not a living will, but you can make an advance directive to a physician, and that can actually be done orally, although it's not necessarily the best practice to wait until you're in the hospital to make the declaration to a physician, because you frankly don't know when that might happen or if you would be able to do it at that point. So hopefully that answers the question.
Okay. And now to transition from what Leanne discussed into estate planning, I would just like to reiterate that in order to be a complete estate plan, it should also include all the incapacity planning techniques Leanne just discussed. Estate planning is basically what we want to have happen after you pass, but those documents Leanne discussed are what happens if you are incapacitated yet still alive. Well, if you have a will or something like that, none of that kicks in until you pass away. So let's be sure that we're prepared for both. So what is estate planning? I think everyone has somewhat of an idea about this. Estate planning is the process by which an individual or a family arranges for the transfer of their assets. To boil it down into simple terms, which attorneys never like to do, it's who gets what, when, and how, right? So who gets the assets? When do they get them? Meaning, do we keep them in trust to a certain age? Do we give them to them outright right away? And how, meaning, do they get them in kind form? Do they receive cash equivalents? Whatever your desires are. So it's basically, keep that in mind. It's who gets what, when do they get it, how do they get it? So a lot of people may not know this, but you already have an estate plan in place. The state has what are called intestacy statutes. These intestacy statutes refer to, intestacy is just a legal term for you passed without a will or an estate planning document in place. So to transition to that, the comparison I always make to people is there is a pothole in our parking lot that has been there for roughly 3.5 years. The state still has not patched it. So we are, do we want to rely on them for an estate plan? They have one in place, but is it what you want? The answer is almost never that it is. So let's take a look at what the estate's plan is. So if you're survived by a spouse and children, at least one of whom is a minor, the state says the spouse receives 1/2 and the children divide the remaining 1/2 equally. Well, in my opinion, if you look right there, there's not a desirable result because it says right away, one of the children is a minor. Do we want to leave money, half of an estate, to a minor? In my opinion, that answer is no, at least not outright. Another scenario would be if you're survived by a spouse and adult children. In this case, the state intestacy laws say the spouse receives $40,000 up front plus 1/2 of the remaining estate, and then the children divide the remaining half equally. Again, this may not be what you want, but that is the language, and that's what's going to take place if you're survived by a spouse and adult children. If you're survived by children only, they divide the estate equally. Notice there also that it doesn't specify age. So if you're survived by minor children and they divide the estate equally, that can create quite the mess as well, right? 4-year-olds can't open checking accounts. They can't sign for bank accounts. They can't own property and so forth. So keep in mind that even if it is children only, and even if you would want them to divide it equally, giving it to them outright is probably not what you intend at that point. If you're survived by a spouse and a parent, the spouse again receives that initial $40,000 and then, and then 1/2 of the estate, and then the parents divide the remaining half equally. If the marriage is less than 5 years, the parents do not inherit, or greater than 5 years rather, the parents do not inherit. So those are the 4 situations accounted for by the state's intestacy plan. The issue being that you may not fall into any of these categories. You may fall into some of these categories or one and not want the state to divide the money in the manner in which they mandate. So that's something to keep in mind, is this is the default if you do nothing. Additionally, it's going to take so this is what it looks like from the state eye without a will. Excuse me, I think we have a question. Yeah, there are other scenarios that are covered by the law, but these are the most common ones. We wouldn't want to walk through all of them for you, but the point being is that the state does have a plan, and it's very likely that it does not match your intentions. Go to the next one. So what's a will? This, again, is the document that everyone thinks of when they hear estate planning. This is the most common one. This is the basic one. Again, to do an accurate and complete estate plan, I would say that this is required along with all the incapacity documents that Leanne mentioned prior. You're much more likely to become incapacitated because you can only pass away once. So what is a will? It's basically a substitute for the state's plan that we just reviewed. It says it controls the flow of your assets that are in your name only that are going to pass through your estate. When I say your name only, that's because what a will does not control are some of the other properties you may own that are owned in different manners, such as, for example, here, life insurance is not controlled by your will. Why? Because when you take out a life insurance policy, there is a beneficiary designated as to who's going to receive those proceeds. That beneficiary designation supersedes your will and will immediately go to that person. That's for life insurance. For IRAs, it's much the same thing. They're individual retirement arrangements, but when you open those, and 401ks is similarly, you have to name beneficiaries. You name directly who you want to receive the assets and when. This is especially important now following the Secure Act that passed in January. There are now different rules for when these IRAs that are inherited have to be emptied, have to be distributed, and so forth, depending on who you leave the assets to. There are exceptions, but generally, if it's anyone but a spouse or a minor child or disabled child, chronically ill person, they'll have to empty that account within 10 years. So you really want to think about that. Transfer on death agreements are also beneficiary designations that would supersede a will. That means that, let's say you have a bank account and you name directly on there, this is the person that I want these assets to transfer to upon death. then that'll happen when you pass. Given when they provide proof that you've passed, it'll go directly to that person, again superseding the will. And then by contract, it's also can be referred to as operation of law. These are accounts that are held jointly with someone else where there's a right of survivorship. So joint tenancy with rights of survivorship means you each equally own the property. When one of the parties in the joint tenancy passes away with their rights of survivorship, the assets immediately go to the other party. Keep that in mind because there are also joint ownership situations where this won't happen. If you own something tenants in common, then you each technically own 50%, and there isn't a survivorship provision. Therefore, operation of law won't help you there. That asset will have to pass through your will, or 50% of that asset. And a trust is an additional estate planning document, a little more complex than the standard will, but that's another way things can pass where they will not have to go through probate. Beyond the will. Okay, again, this is these are for things that are going to pass outside the will, things that we already want to take a look at. You likely already have documents that control the distribution of assets after you pass. Again, these are your beneficiary designations, maybe some transfer on death items, things that say this is what I want to have happen. I can't stress this enough with the Secure Act. Please check all beneficiary designations for retirement accounts and life insurance proceeds. I had a case that I can recall, especially this was for retirement accounts, where a person had gotten married, spouse passed, they divorced, person got remarried, then passed away, never changed the retirement accounts from the beneficiary from the original spouse to the new spouse. New spouse had to give ex-spouse all the retirement assets because she was named beneficiary. It was not a pretty situation. So again, in light of the Secure Act, please make sure you check all your retirement beneficiary designations. It's, for the most part, very easy, a one-page form to change them and make them the way you want them. And keep in mind that if you're giving assets from a retirement account to people other than some of the exceptions, they'll have to empty that account within 10 years. So the reason I bring that up is if you have a child that's, 18, 19, 20 years old, maybe you don't want to give them all those assets and have them have to distribute it all within 10 years. So that's something just to consider, but I strongly urge you, if nothing else, to go check those and just make sure that they read the way you'd like them to read. Consider adding a trusted family member to bank accounts or designated accounts transfer on death. As far as bank accounts go, it may be even better to do the transfer on death to a family member. If you add them to the bank account, they have ownership interest then. They could technically write a check, take the cash out, do whatever. Again, that's why it says trusted family member. We do have a question pop up. It says, when do you need a trust? We were actually going to get into trust shortly, so I'm going to leave that question for just a moment later. So again, you can add transfer on death language to your bank accounts and so forth, and some investment accounts to make sure things transfer immediately if that's what you'd like to have happen. Real estate deeds, you can check those on mdlandrec.net. That's the website that you can go to see how your deeds are titled. Again, I actually am working through a case right now where it would have immediately been resolved, but someone back under the old estate planning laws had the house titled tenants in common instead of joint tenants with rights of survivorship. So now the house doesn't pass immediately to the spouse. It had to go through its own probate proceedings first, and now we've got to do another one. So check your real estate deeds, make sure that your deed reads the way you want it to read, has survivorship provisions if that's your intention, and just make sure that it is going to operate the manner in which you want it to operate. So if we can move to the next one. What is probate? This is the ugly word in estate planning, right? This is the one that makes everybody cringe and turn in their seats, and this is the one they want to avoid. So let's just take a quick look at it. Probate is basically the legal process that takes place after someone dies. It involves, identifying the person's property, appraisals for said property, which have to be valued based on the date of death, paying debts and expenses of the estate if they're valid, distributing the remaining property if there's a will as the will directs. If there is no will, we're back to that state law intestacy chart that I referenced earlier. So this whole process can be quite long and onerous if you don't have documents in place, especially. The more documentation, the better that your things are written up and in place, the easier this process will be. for the person who is in charge. And remember again that only assets that are owned exclusively by that deceased person without a beneficiary designation or without rights of survivorship will pass through probate. So keep that in mind. If don't think that your IRA is going to go through a probate process or something that you own jointly with rights of survivorship. Those assets are going to operate outside of that. We do have a question. Any way to ensure joint tenancy with rights of survivorship on bank accounts? Yeah, as far as ensuring joint tenancy with rights of survivorship on bank accounts and so forth, it should merely be a call to your bank and just say, hey, I want to make sure this is titled the way I'd like it. And just confirm with them that there are indeed rights to survivorship, or conversely, a transfer on death provision, if that's something you want to have as well. And this go ahead.
Sorry, I was just going to jump in on that. For bank accounts, generally in Maryland, if you own a joint account, unless you specify otherwise, survivorship's usually the default. However, you can specify otherwise if you want to have a joint account and not have survivorship.
Right, but this, as far as calling and confirming, though, the bank should be able to tell you right away if it's a survivorship account or not. So that's something you should at least confirm. It doesn't cost you anything to do it. It's worth looking into just to make sure that you understand how everything's placed and what you have. And again, this process is overseen by the Register of Wills in Maryland, but it's overseen by each county depending on where the person passed away. So keep in mind that every county has little nuances. The process is generally the same, but the county Register of Wills is where you're going to start when something happens that you need to initiate this process and begin legal proceedings through probate. So now I'm going to turn it back to Leanne, and she's going to start into a question that we had earlier about trust. She'll get to that.
Yes. So what is a trust? On the most basic level, a trust is an arrangement between three different people. You have a person who is a grantor. This is a person who creates it, writes the instructions, and puts the property into it. You have a person who is a trustee, just like what it sounds. The trustee is entrusted with managing assets and carrying out the instructions. And then you have a person who's a beneficiary, who, like it sounds, is a person for whose benefit the assets subject to the trust are held or managed. So it's a vehicle to basically hold assets for the beneficiary by the trustee. And while the trustee is holding the assets, they serve in a fiduciary capacity, which subjects them to certain responsibilities to manage the assets responsibly and use them properly for the benefit of the beneficiary. Sometimes when you're dealing with a trust, as I mentioned, you have these three different roles: the trustee, the grantor, and the beneficiary. They can be the same person, or they can all be three different people. There are a lot of different types of trust, and what types of trust would benefit you or whether one would benefit you at all really depends on your individual circumstances. They can be used for Medicaid planning. They can be used for asset protection. They can be used for transfer tax planning, that's estate and gift tax planning, sometimes income tax planning, or just on a more basic level, they can be used for probate avoidance. Using trusts, some of the pros of using trusts are that they generally would allow for greater control of your wealth. They provide some additional layers of privacy for the parties involved. They save money and time on probate, and they can offer more sophisticated planning for the event of incapacity. The downside of using trusts is that there are generally much higher legal fees to have them set up. You have to go through the process of transferring assets to them, and they can often require ongoing administration. So depending on how it's set up, you may have to file a tax return for it every year. Depending on, again, how it's set up, you might have to be paying a trustee, or you may have to pay for legal fees for ongoing administration. So the first type of trust that we're going to talk about is this is the most commonly used trust, and it's probably the one that the person asking our question was thinking about. It's a revocable trust. They can also be called a living trust or a revocable living trust. Primarily, these are used these days as an alternative to a will. And it works because, as Rob was mentioning earlier, the assets subject to probate are those assets that you own in your own name. By retitling your asset, so for example, a house, to your trust, it takes it out of your own name and then causes it, by virtue of not being in your own name, to not be subject to probate. The other primary advantage of using a revocable trust these days is that it can offer some enhanced incapacity planning over top of using a will. Just because if you have a will, you'd be using a will in combination with powers of attorney. If you use a trust instead of a will, things can go a lot more smoothly, and often you wouldn't need to have a power of attorney. You would still want to have one, but you wouldn't necessarily need to rely on it in the event that you were incapacitated, because the financial institutions would already have the information about who your co-trustee is or who your successor trustee is. Another way they can be incredibly useful. So jumping back to probate for just a minute, generally you have to have a probate in the state in which you reside, and then also in any state where you hold real estate. So for example, if you live in Maryland, but you might own a vacation home in Hawaii or California or somewhere, anywhere else, you would generally need to have a probate in Maryland, which is a state where you live, and then you would have to have some sort of ancillary or a foreign personal representative probate in the states where you own this real estate. If you put the real estate into the trust, then it would avoid having to have 3 different probates, again, because the real estate's not owned in your name at that point anymore. And then the other thing that it avoids is that typically the contents of the trust, unlike your will, would not become public record through probate. And then sometimes people will ask questions about the tax benefits of using a trust or a revocable trust. There are none in this case. There are different types of trusts that do have some tax advantages. But when you set up a revocable trust for tax purposes, it would just be treated as you. So it does not cause you to have to file a separate tax return. The assets in it continue to be taxed to your tax and report to your Social Security number. Another type of trust that comes up a lot, or that people would ask for or about, is a Spendthrift Trust. When you're thinking about Spendthrift Trust, you might really be thinking that it's exclusively used for somebody who has financial problems, or an alcoholic who spends all their money on booze or something like that. That's really not the case. Spendthrift trusts have a much wider range of usefulness. Basically what it is a legal mechanism for protecting the assets of a beneficiary of a trust. And the way it works is that when the assets are put into the trust for them, the trustee has certain guidelines about when and what and how they can distribute to the beneficiary. And the beneficiary's rights to receive the assets of the trust are limited in such a way that his or her creditors would not be able to have a claim against them. So while this can be a really great protection tool if a child has addiction problems, it can also be used if they have current creditors, foreseeable creditors, or I guess a creditor that somebody doesn't generally see as a creditor, a divorcing spouse. It can keep the assets protected from that circumstance as well. In Maryland, you cannot create a Spendthrift Trust for yourself. So these are really, and at least in this state, they are an asset protection tool for a beneficiary. There are states that would permit you to be able to set up an asset protection trust for yourself. Some of these are Delaware, Wyoming, Alaska, Nevada. There are a couple others, but these four generally have the better protection laws. And so even though you can't create one in Maryland, though, as a Maryland resident, you would be able to avail yourself of the laws of one of these other states to use one for yourself if you were interested in that. All right, I'm going to turn over to Randy now.
Thank you, Leanne. As the slide shows, there are different ways to protect a disabled person that legally can't take care of themselves. One of them is a guardian. One of them is a bank account called Uniform Transfer to Minors Act, otherwise known as UTMA. And the third way is using a trust. The advantage of using a trust is you can control when a child inherits control of funds so that they're emotionally able to deal with those funds. Some people think let a child have it at 21, and if they blow it, so be it. Some think don't let them have it till they're 40, because they'll know that all that will happen is a red Corvette will appear in the driveway, or a large stack of brand new shoes from a shoe store, or something similar. Uniform Trust to Minors Act is a way to deposit money into an account and be the custodian until the child reaches 21. And there's no court oversight of that type of account. But what happens is that at 21, they have control of the funds. So there's a trade-off from simplicity for control when they're much younger, but as they age, you have to hope in the back of your mind that they're mature enough to handle it at 21, or they'll regularly accept guidance at 21. Nominating a guardian is typical for a minor. Parents pass away, a minor is left. The minor is going to have a guardian, or a disabled person that becomes of age. I've done a number of court appointments representing the child that is about to become of age, because once they become of age, the parents have to become appointed as the guardian. This takes in oversight and can go beyond when the minor comes of age. Beyond that, Leanne, if you can roll it to the next slide. Death taxes. There's a federal estate tax that is imposed at a 40% level for a decedent's assets over 11.58 million. The nice thing is married couples have portability both at the state and federal level, so that the 11.58 becomes 23 million and change. But that's a higher end issue that needs to be addressed for wealthier clients. Maryland taxes somewhere between 8 and 16% on a decedent's assets over 5 million. There's also portability in there. Now, estate taxes need to not be confused with inheritance tax. Estate tax is a tax on the size of the estate, regardless of who it flows to. The state of Maryland, in its infinite wisdom, charges a tax on bequests to non-linear descendants, such as children, brothers and sisters, parents, stepchildren fall into that. Step brothers and sisters fall into that, but nephews, cousins don't. If you leave a bequest to a niece, a nephew, a cousin, Maryland is going to charge either 10 or 11% on the transfer, depending on how the tax is paid. There's no income tax on inheritance equally. The exception is retirement type assets, which I think next slide, Leanne, if there is one, takes us to the final thoughts. You want to take time out to develop your plan. As I said when we started, there are two major things that happen. There's pain and there's chaos. You want to let us help you avoid the chaos. We can't do anything about the pain. We can only help you through where you need to go. You also want to need to plan for incapacity. A reality also is C19 patients are going to be alone, so that if, God forbid, you come down with the virus, you could go into you could go into isolation. There are a lot of stories about people dying in 10 to 12 days from the virus, and they were alone for the entire 12, for the full length of it, because they have to go into isolation and not infect their own family. So this is why it's important to take this and think about it, and try to get it lined up like you want. Leanne, I'm going to turn it back to you for any final thoughts you might have.
Oh, great. Okay, well, I think this is the end of the general presentation that we have. So we'd like to thank all of you for joining us today and taking the time out of your day. We will have some time for Q&A if anybody wants to stick around for questions or to talk to us in more detail about anything. Before jumping to that, though, in case there's anybody who is ready to jump off, we just wanted to say that if you're interested in working with us on your estate planning or estate planning for a family member, everybody who attended today's webinar will receive a follow-up email. And the email will contain our estate planning organizer, which is what we use in moving forward with the next step working with us. And so if you're interested, when you get that, please take the time to fill it out, and you can return it to us and schedule a consultation. The follow-up email should have more details on that. Generally, when you work with us, you would be meeting with us in our office for a consultation, but given circumstances, obviously, we are talking to you today from our homes. Generally, we're thinking it's more responsible to do consultations over video these days. But for signings, we do offer limited appointments in the office. And as you may or may not have seen, Governor Hogan passed some executive orders recently that are permitting remote execution of estate planning documents. If you are tuning in for the webinar today, you probably have the technology available to partake in a remote signing. So we are working with everyone to figure out exactly what the best way to do that is, given their personal situations and the virus. So we will work with anybody to figure out how to do that. And I think that's really all for the presentation part today. So thank you everybody for joining us. And let's see, I think we do have perhaps some questions that we'll get into. Okay, so we have a question. First question, I think, is if your spouse has dementia, what is the best way to ensure that she is cared for properly and that no one takes advantage of her and her assets after your passing. So if you have a surviving spouse who's not going to be able to manage assets, you probably want to leave those assets in trust for the surviving spouse, and you would want to most likely nominate a trusted family member or friend to be in charge of managing the assets for that person. Randy or Rob, do you have anything to add to that one?
Well, I'm interpreting his question, Leanne, as that that is the disabled spouse's husband. So he has the ability to have her, at this point, declared incompetent so that a guardian could be appointed for her.
Got it. Yeah, so you could have a guardian nominated for that person and then also leave assets for them in trust.
That's correct. I mean, you definitely, I think, would want to leave the assets for them in trust. The design of the trust might include, depending on the age of the disabled spouse, it might include a caregiver panel in case the disabled spouse outlives her husband. I'm taking the assumption that the one that is disabled is a female, and that question came from the husband. So some of that goes to age, some of that goes to illness. Some of the dementia patients can live quite a long time if they have good care. So they may be around for quite a while. So they may want a double layer of protection.
Yeah. Okay, next question. Hopefully that answers on the dementia. The next question is, for a power of attorney, can an agent or a successor agent serve as a witness for the execution? And I believe the answer to that is no.
I would agree. I think you always want to have an uninterested party be the witness to these, so it can never be questioned later.
Let me agree with my colleagues. Leanne, Rob, I'm thinking the changes in the Maryland Trust Act said that a notary could be a witness, which allowed for smaller attorney shops to execute those documents with less bodies around, but not the agent in a power of attorney. So I'm thinking you're right.
Yeah, so I think we think that's the answer, and even if it's not, even if a witness could potentially serve, or if an agent could potentially serve as a witness, we would certainly recommend that you don't have them do that, just because it creates a situation where even if it was legally permitted, the financial institution probably wouldn't. It would be highly questioned, I think. But we believe that they cannot legally do that. Okay, next question. Please discuss the impact of a irrevocable trust. Someone want to take that one?
I'll start. An irrevocable trust takes money out of the giver's estate so that you are giving away complete control of whatever the gift into that trust becomes. It's a higher end tax planning vehicle. It's a higher end estate planning vehicle. And it's not something you use without working with professionals to make sure you have the best advice on it.
Yeah, I mean, the bottom line of an irrevocable trust is that when you create it, you can't change it, and that's what makes it irrevocable. There are a lot of different types of trusts that are irrevocable and that you could use, and yes, generally speaking, you would be using them for transfer tax purposes or income tax planning, perhaps Medicaid planning too. You could be using them for that reason, but bottom line impact is you can't change it, I think. And if you have follow-up questions on that one and you would like to speak to us about it in more detail, or you have more targeted questions, we're happy to discuss. Okay. Randy, I think I'm gonna request that you answer this one. Would love to hear about how to pass down a family business and how the process differs for C Corp versus LLC.
The shortest version to a long answer is that C Corps and LLCs pass by change of control. There are gifting strategies that can work. There are high-end irrevocable trusts that can work for the basic purchase of the business. The issue with an LLC depends on how it is taxed. So I can't really give a detailed answer sitting here right this moment. There's more we would have to know about passing down the business. The things that we need to know, is the business generating cash? Is the business going to a family member that knows how to run it, who's been dedicated in working in it? Is the business has to be able to survive, so the price has to be right. So there's a lot of moving parts to it. The key element for us today to say to the questioner is you can do essentially the same things with C Corp and LLC. There are other tax considerations that we'd want to break, peel the onion back and look to see what we found to make decisions about how to do it.
Okay. Hopefully that answers the question at least enough to know what you would need to follow up about. Okay, next one, I think for Rob, if you can take this. If I want my retirement funds to go to my children, now 5 and 7, at age 21, can this be arranged with the investment company holding the funds, or do I set up a trust?
Well, given the Secure Act, they're intended to inherit at 18 years old. So the Secure Act has a deferral for the 10-year rule requiring that the accounts be fully distributed for minor children. Minor children are one of those exceptions. So they still would have to distribute within 10 years, but the clock wouldn't turn on until they turned 18 years of age. The trust is going to be subject to that. They're still going to have to distribute within 10 years. So that's not really going to accomplish a lot other than delaying it for 3 years. But basically what's going to happen there is their 10-year clock will turn when they hit 18. And I don't think the investment company themselves is going to agree to hold assets until the children turn 21. So the only way to ensure that would be, I mean, you could do a trust to hold that, but they would still have to have it fully distributed by 28 years old is my interpretation.
All right, next question. Considering the COVID-19, how can one execute a will or a trust with the sensitivity of time? So we mentioned earlier that there are executive orders in place from the state of Maryland that are permitting remote witnessing and notarization of estate planning documents. And the details, kind of the how and why and how all that works together, is somewhat complicated as far as how it needs to be done, but it can be done. For somebody, like, for example, Rob, Brandy, and me, we're all in different locations, but assuming that we met the formalities required by the governor's orders, Rob and I could serve as witnesses on Randy's will, or one of us could notarize his trust, just as long as we require the formalities of as long as we follow the formalities of the orders regarding what has to happen and what needs to be transmitted between who, and there's a supervising attorney certification that needs to be done. So it's very detailed, but it definitely is possible to execute documents in that way. And in addition to remote execution, you can always use traditional witnesses and notaries. There are traveling notaries, or we call them mobile notaries. You could generally or possibly use a neighbor to witness a will if you are housebound and can't get out and don't want to use remote. Or, if you're able to travel, our office is open for limited visits. So we can accommodate and schedule in that manner. So we're kind of in a position of where we're trying to figure things out, but can make something work for everybody, I think. Let's see. Can legal action be taken against a family member who has taken advantage of a parent with dementia?
I can, Leanne, I'll do it. The short answer is yes.
Yeah.
It's not within our wheelhouse of expertise, but there are law enforcement people in the county that would investigate and pursue that if the evidence is there.
Yeah, there are elder abuse laws in place for both financial and, I believe, physical and mental abuse of individuals who have dementia. So it's definitely possible to initiate legal proceedings against them. It's not, like Randy said, it's not really our wheelhouse, but if you have this type of issue, you can contact us and we can refer you to somebody.
Yes, I've got a couple of attorneys that do that regularly that we can refer.
Yeah.
So we have a book of people we could send them to that would get them taken care of correctly.
Yeah. Okay, next question. If my minor is the inheritor, can I stagger the distribution? Does his or her future spouse have rights over that? The short answer is yes to the first question. You can stagger distributions if you use a trust. And does the future spouse have rights to it? Depends on what you do. Generally, if there's going to be distributions out, the child would have an opportunity to commingle those funds with a divorcing spouse's funds that could subject them to being claimed in a divorce, but it's definitely possible to set up for a beneficiary in such a way that they're not subject to rights of the future spouse.
Agreed. And if that's a situation you're concerned about, the way to do that is have only the inheritance into the child's name only and be able to trace it back directly to the inheritance and not commingle it, as Leanne suggested. And if you do that, there's much more likely that you'll be able to say that's not a marital asset because you've kept it separate. You haven't used it to pay common bills with a spouse. You haven't commingled the funds.
Yeah, and the real answer, also, if just to add on that, we had mentioned Spendthrift Trust earlier, and if you want to make sure that a child's future spouse wouldn't have any rights or way to get at their inheritance, that's the most protective thing. All right, next question. Is it recommended to put properties owned by an individual into an LLC? Randy, you want to take that one?
Happy to. The lawyer in me says LLC first, ask questions later.
Yeah.
Because those properties, what you're doing is protecting each individual piece. You can enroll them up into a more manageable holding company on the top, but you have to be aware of what state it's in. There are certain state laws that are different, and so we'd need to know a few more facts before we could help them greatly. But the short answer is yes. You always want to put rental properties, whether it's commercial or personal or residential rather, you want to separate them out so that if something happens in that location, it doesn't subject everything to litigation.
Yeah, and just to quickly add to that, we had talked about, so what Randy's talking about is for rental properties where you have other people coming into the property and using it, and they could sue you potentially. You might have a circumstance where you have properties out of state and you want to avoid probate in that state. Using an LLC can be beneficial for that reason too, or also potentially for trying to avoid estate tax in a different state where you have real estate. Sometimes using an LLC can get it out of that. So a lot of good different reasons why you might want to use one. Okay. Next question is, can the person named as your power of attorney for healthcare be somebody who is a beneficiary in your will?
Yes, that shouldn't be a problem. There are different documents. When you pass away, the healthcare power of attorney ceases to exist anyway. So then, yeah, there shouldn't be any issue with naming someone that is a beneficiary in the will as also being your healthcare power of attorney.
Yep. Okay. I'm trying to read this next question. I'm a little confused by it, but I'll just go with it. Okay. Power of attorney, mother's assets, life expectancy short, siblings, suffers from mental illness, concern regarding medication compliance, Spendthrift Trust. What kinds of conditions and distribution options are there?
Leanne, I looked at it. I'm going to interpret it this way: that the question, she has a power of attorney over her mother's assets. I'm going to interpret it that the mother's sibling has an illness also. Wants to know if a spendthrift trust is the right vehicle.
Got it.
And
yeah,
she has concerns about medication. And then what kind of...
So the mom's child has the issue. So I guess before you can really even look at how to fix this, I think you'd need to look and see what the power of attorney covers, because the power of attorney may allow you to create a trust or may allow you to do some form of estate planning for your mom's assets. But if it doesn't say that in it, generally you wouldn't be able to use it for that purpose. But it may be beneficial to use some sort of spendthrift trust for the sibling, or have somebody in charge of their inheritance for them.
That's how I read it. The other thing I think we as practitioners would want to know are more details on the state of the mom.
Yeah.
Is the mom just old, or is the mom disabled in some fashion?
Yes. But I think that's okay. Next question is, are you required to file a will, or can it be placed with someone or in a safe deposit, etc.?
You're not required to file it. The only time you're required to file it is when that person passes away. You can file it with the Register of Wills, but it's not a requirement. I typically discourage people from putting them into safe deposit boxes because the document granting you the right to access that safe deposit box is now locked in said safe deposit box. It's the equivalent of locking the key in it. So I encourage people not to do that unless you have the personal representative already have access to that safe deposit box. But otherwise, in a safe place in your home. And when we execute them, we always keep a copy as well.
Yeah, and touching on the Register of Wills filings, like Rob said, you can file it with the Register of Wills, but you do have to be careful if you go that route, because you probably would file it in the county where you live right now. If you move at some point, you would need to get it. And if you ever update it or do a new will, then you need to make sure that you are following through and retrieving the old one or filing the new one. Can cause problems when people move around, or if they update a will and then they don't file the new one. So not always the best solution, but you can do it. And I think we have one more question. For properties located in Maryland, how long does the process take for setting up the LLC and the transfer to the LLC? So that depends a little bit. You have to do a new deed generally to transfer the property into the LLC, and it would depend on how simple the LLC that you're creating is. If it's particularly simple and it's a single member, it's not going to take very long. I mean, practically speaking, probably a week or two. But if you have more members in the LLC and you're setting up an operating agreement and taking all those additional steps, it can take longer. Do you have anything to add to that, Randy?
No, just straight up, there is a way to file for expedited service, which obviously costs more. If you don't file for expedited service, it's like 6 weeks. If you file for expedited, it's 3 to 5 days. But that's a cost question that sometimes people don't want to deal with. So that's one of the decision points also.
Great. And do we have one more in here?
Yes, it just came in.
Let's see. Oh, that the mother has an advanced dementia. Yeah, so if that's the case, this goes back to the same question about the mother who has dementia, the daughter's power of attorney, and trying to protect the inheritance for a sibling who has addiction issues. So if the mother has advanced dementia, you're really going to have to look and see what the power of attorney gives you authority to do, because you're going to be limited by that in what you might be able to do planning wise or
go the guardian route.
Yeah.
Those are going to be your two choices, really.
Okay.
All right. Hearing no other questions.
Yeah, I think that's all. So I don't know how many people we still have on the webinar, but I think we'd just like to say thank you for everybody who took time to join us today. We hope you learned something. And if you have further questions, our contact information is on the PowerPoint, so you can always reach out to us and follow up, and we'd be happy to help.
Thanks, everyone.